Okay, so you rip down a statue at a demonstration, you vandalise it, chuck it in the river. 4 of you are taken to court for criminal damage under what I think was the Criminal Damage Act of 1971. You spend all your time in court, or your defence lawyers do, basically talking about the history of slavery and what an appalling person this man was, whose statue was taken down, the Colston statue in Bristol. And a jury decides to say, you're not guilty of criminal damage. And I'm going to be talking to a lawyer about this who will correct me if I'm wrong. But basically, as I read it, that there was an implicit defence put forward that to this charge of criminal damage, if we, the defendants, genuinely believed the owner consented to us doing this because of the awful history, then it's not criminal damage and it's justified. And it seems the jury agreed with them. Interesting if we take that analogy further. But let me try and get some facts on this from my next guest. Very pleased to welcome Joseph Kotrie-Monson, Director of Mary Monson Solicitors. Joseph, thank you very much indeed for joining me.
Good evening, Nick. Nowhere I'd rather be.
Yeah, okay, well, you said that very convincingly, so I'm very impressed. Now, look, I've given that analysis, a very brief analysis. Is that broadly right, or is it more complicated than that?
Honestly, I think you've probably summarised something that I'd give you a little 3-minute deep dive on, really. Very interesting to look at the background of Bristol, of course, because it's this melting pot of a port city. It's extreme poverty side by side with extreme wealth, and a history in the last 30 years of riots, sometimes linked to race, every 5 or 10 years over that period. You have these 4 defendants you pointed out. They've tied ropes, 3 of them, around the statue's neck and used it to pull it from its plinth. Divisive character is what the prosecution said about him. Mass murderer is how he was described by an expert who was not cross-examined, a professor of history, I think, who was not cross-examined by the prosecution because they accepted broadly the evidence that he gave. The context for this, and this is something that weighed heavily in court in the defence arguments, this is a man who was in the direction of a slave trading company that was responsible for the kidnapping, transportation and sale. Many of those won't have, around a third probably will have died on the journey, of 84,000 men, women and children from Africa. By any modern standards, probably no lawyer in court would have argued that his organisation was an organisation of mass murder. Of course, it was a different time, etc., etc., etc. But you've essentially summarised the main thrust of those different positions. Interestingly, Liam Walker, for the defendant Sage Willoughby, said it's a kind of combination of the 2 of the things you've said, Nick, and that's that he said each of the defendants were on the right side of history. There's that kind of the jury can do what they want point rather than necessarily follow the law, but in fact said that they were on the right side of the law. He said that the veneration of this man in a vibrant multicultural city, with my parenthesis, overlooking a historically black neighbourhood within the city of Bristol. He said that was an act of abuse, and the presence of that statue not only normalised abuse, and I'm summarising here, but interestingly, and these are words that were used, the continued existence of that statue was a racist hate crime. Now, by using the phrase racist hate crime, of course, he's chiming in to something that we know is a hot point, something that we know is an offence, etc. But of course, the fact that something is a racist hate crime isn't necessarily a defence to the offence of
no, but it must put
damage.
Huge pressure on a jury, which the judge basically said to them, ignore the claim of the defence witness that says the weight of the world is watching your decision. Absolutely. Or words to that effect. Absolutely. I mean, in a way, it was clever to avoid having this settled in a magistrate's court and try and influence a jury. But and there's part of me, and this is my dilemma, because I don't want...
I think you would have had a decent run with three magistrates, three lay magistrates on the same thing.
Okay.
But it probably would have gone to a district judge in the magistrates court who would have laughed you out in the way you described. But carry on.
Okay, I mean, part of me thinks the jury system, a big part of me, in fact, no, I would say all of me, is the jury system is vital. I don't want judges or politicians deciding all our cases. As an MP, when we talked about reducing some of the cases by jury, I vigorously opposed it. So part of me thinks, well, you've got to take the good with the bad, because I think this is a bad decision, so that's why I would say that. But now I notice the Attorney General is seriously considering actually appealing the decision. She's, as I understand it, there is a legal basis she could do this on. Is that correct?
It's grandstanding, I have to say.
Okay.
Yeah, I mean, it doesn't sound like a particularly impressive move from the AG.
Could she do it? Could she do it?
Well, she can refer it. I don't think she's going to get anywhere. And to what end? Because once somebody's been acquitted, the prosecution can appeal, but only to clarify a point of law. And this is a point of law, Nick, that goes back to 1670. Let's go. You know, if you like, I'll explain where this comes from, because it's interesting. It's being presented at the moment as if it's a new development, something that's of worrying new concern to do with the way juries can make decisions. This actually goes back. The principle, they call it jury nullification, the idea that a jury can make whatever decision they want, and that is sacrosanct, and they can't be punished or censured for coming to a conclusion that seems far-fetched. It goes back to a case called Bushel's case. If you go to the Old Bailey, which is open to the public, or at least was pre-COVID.
I'll rush down there. You're not going to tell me this is a case in 1674 I've got to read, are you?
No, it's not. In fact, there is a plaque commemorating it.
Okay.
On the left-hand side of the ground floor as you walk in. And it was a case in which jurors at the Old Bailey refused to convict two Quakers, William Penn and William Mead, of unlawful assembly. Pretty much, I suspect, on the basis that assembly is pretty much a right that everyone should have. Penn would go on to found a little place in America called Pennsylvania,
yes,
for which we have to thank for the greatest film ever made, Rocky. Since then, the principle of this jury nullification has been considered this sacrosanct right. And in the rare cases where the law or the application of the law, the decision to prosecute, whether something's in the public interest, doesn't follow the views of the jury, they can make their own decision. The truth, however, is this is a lot more common than people might realize from cases like this, because juries will often not convict somebody if the case against that person is somehow repugnant or rotten. And I can give you a couple of examples.
Just bring this to there is a huge part of me thinks, that's one of the good things, because sometimes the law can be a bit of an ass. I don't think it was in this case. I clearly think it wasn't. But that my backstop is 12 of my peers might get me off because they'll see it in a different
principle
way.
We trust. It's a principle we trust, isn't it? The idea that 12 people who aren't millionaires or who aren't gentry or who aren't out of touch judges, although I have to say most of the judges I've actually met have been a lot less out of touch than the reputation, but these are often people we like the idea of trusting somebody who could be our neighbour, somebody they might not be from the same cultural background or earn the same as us or whatever, or be a woman if we're a man, but we just trust them to have
Joseph, can I draw you on that though, right? Because one of the things I think people also like is consistency, and it could be someone goes and gets banged up or gets fined or whatever for vandalising something, and they're going to look across and think, how unfair was that, just because I did it to a dustbin or something. But let me give you a slight, I think, an example, and I ask you this question based on what I'm about to tell you. Would this jury decision set a precedent, or is it entirely up to each jury? And let me just explain. I was looking at the Daimler-Benz website, of course, owners of Mercedes-Benz. And they freely write here how they use workers from Eastern Europe and prisoners of war, concentration camp detainees monitored by the SAS under inhumane conditions to their company to work for the war machine that was Daimler-Benz at that time. This is on their website. Now, if I am so incensed by this, and I go out and destroy a Daimler-Benz in that same part of Bristol because I'm deeply offended, or I go and destroy it in a town that was heavily bombed by the Germans, you know, someone might say, well, there's no difference to that and the statue. So how would it work?
Yeah. Two-part answer to that, I think, Nick. First of all, as your attorney, I temporarily advise you don't do that. And secondly, as far as...
To go out and do it? Yeah, well, okay, fair enough.
I think the critical question is, are 12 people likely to be persuaded? And the answer is no, isn't it? You know, I personally, you know, and I think that it's very difficult to be objective when you're one person making a decision. But this was unusual, wasn't it? And each case does turn on its own facts. That's why, for example, prosecutors have a code that they're supposed to follow as to whether something is in the public interest. How this prosecution could have been in the public interest and is an interesting moral question. But on the other, and you can see the law and order argument, can't you? Because you can't, you know, it's not something to be promoted, but should there be a sense of measure and consideration of all the factors? You know, I think that's part of it, but I have to say that one other interesting issue here, Nick, is that, you know, these guys, Bristol City Council, it was in their gift to put this issue to bed when the thing gets toppled and ends up in the museum. You know, instead it went for this show trial. That's just continued the platform for these protesters.
Well, was it then? Because I thought prosecution would be decided by the CPS.
Not unlike, but in criminal damage, it's property belonging to another, and you must have the support of the owner.
So they basically said, we're happy to prosecute, or we want
absolutely.
to prosecute. Okay, now just, I agree with you, by the way. I'm not recommending that I go out and do those things to Mercedes-Benz. I use that as a comparison. But does that mean basically that the law, every time you go into courtroom, how much of it is a lottery?
I think you're betting on the jury system, and you know, I tell clients it's a system I believe in. It's not perfect. You get lazy jurors. You might get 2 or 3 out of touch jurors. But the way the dynamic in that jury room works, which I've never witnessed, you know, but the way that secret environment promotes decision making and responsibility among 12 people who have heard all the evidence and have the common sense and experience of their lives, that to draw on, that hive wisdom is something, you know, I really think is so special. When I hear about, for example, the inquisitorial system in European legal jurisdictions, which I'm sure is made to function effectively according to all the checks and balances they have. I have to say, Nick, I get a bit queasy. Long live our jury system, you know. And
I'm with you on that.
If those guys were in court and they heard everything and they decided that this thing shouldn't, it was an ongoing insult for it to be there, irrespective of what I think about the arguments on both sides. And I have to say, you know, you'll always be sympathetic as a citizen who wants order to both sides, even if the person in question was repugnant. You know, I think they having heard everything know better than me.
But do you sense, and honestly, I will let you go in a minute. Do you sense though that we're, if you like, moving from what I would describe as a rules-based system, where we always thought the law was pretty clear in the case, say, of criminal damage, to, if you like, putting more weight onto values, which is more of a political act in a legal environment where really you don't want politics coming into a courtroom, do you?
Yeah, no, but I mean, the criminal law is a combination, not just of the legislature and the executive, but the you know, and the judiciary, but but the jury itself, and they are actually part of the forum in which that law is made. They're a final check which validates the existence of that law. For the most part, juries do as invited by the judge, but they are aware of their importance. They're aware of their ability to think independently. They're rarely asked to, and it's rarely appropriate. I think when it happens occasionally, it's actually a freshening and a wake up to our legislature and prosecutors who take cases when they arguably shouldn't.
No such thing as an open shut case there. Joseph Kotrie-Monson, Director of Mary Monson Solicitors. Thanks very much. A fascinating chat on that. What do you think? How annoyed were you, or do you have faith in the jury system with what happened in Bristol?